First, an overview of the debate which we call the tragedy of the commons and the tragedy of the anti-commons, which plays a very big role in law and economics. And then we will proceed to the economic analysis of contract law. But let me first draw some conclusions which we have not yet drawn from the Coase theorem. I have told you that the Coase theorem aims at analyzing and finding out what allocative consequences a legal norm has if it is a default rule, if it is not a mandatory rule but a default rule. And the research strategy which Coase used for this was not to directly ask what the consequences are, but to describe a situation in which there are no consequences at all, at least not on the allocation of resources and on the efficiency of the resource allocation in the sense as we have discussed it. And he came then out with the proposition, which later became known as the Coase theorem, that if we have the legal norms clearly specified, if we have a clearly specified set of legal norms, and if transactions cost, that is the cost of making contracts and the cost of enforcing contracts are zero, then the legal norms have no effect at all. And I've tried to illustrate this with this example. This is, however, a broad and very widespread and very fundamental insight which we can extend to many fields of the law. Now, for instance, the Coase theorem gives us also an insight about whether or not, for instance, in tort law, the number and severeness of accidents will be the same or will be different if the tort law rule is a negligence rule or if it is a strict liability rule. If transactions costs are zero, then there will be no difference. For instance, would the number of accidents, of car accidents, change if we would allow drunken driving? Under the Coase theorem, we would say no. The number of accidents, if drunken driving would be allowed, would be exactly the same, because then, in the absence of transactions cost, we would all buy the driver's license from the drunken drivers, right? So they would not drive. Just as an example, it's a crazy example, but it shows, the line of thinking. Now, of course, transaction costs are not zero. Sometimes they are very high. Now, if the transaction costs are higher than what the parties can gain from changing the initial allocation of rights and of legal norms, then it is very, very important to get the legal norms in such a way, to specify them in such a way that they lead to the efficient solution right from the start. Now, what does this mean, for instance, for such cases here, damages? Now, assume, for instance, that we have a situation in which it is clear that a polluter, for instance, that the pollution causes so much harm that the pollution should not take place. You know, that the pollution is so harmful that it should not take place. Assume, for instance, that we have a residential neighborhood, a large residential neighborhood, and then we have a paper mill in the middle of this neighborhood. Or as when I was a student in Cologne, we had I lived in a residential neighborhood in which there was a chocolate factory which polluted a lot. Now, if we have such a situation in which it is absolutely clear that the damages are much higher than the cost of removal of the factory, for instance, what should then the legal rule be here? We are talking not about administrative law, but we are strictly within civil law. Injunction, damage, no rights. Injunction. Then people would make use of their right to injunction and would force the polluter to close down his polluting activity and go somewhere else, right? So in that case, the injunction is the right thing. It would lead to the lowest cost of, procedural cost, court cost, and so on. We have a clear situation, the legal situation is clear, people make use of the injunction, and the polluter goes, right? Okay. Now assume that it is absolutely clear that the cheapest cost avoider, the person that the pollution creates so much value that the cheapest cost avoider can easily remove. What would then, at relatively low cost, what would then the best legal situation, the best legal endowment with rights be? Damages, yeah. Well, one could argue damages, but if we have a situation in which it is clear that that the pollution should take place, assume that, then the a damage award would lead to the efficient solution. And so far you are right. But a damage award would also lead to a situation in which we have high costs of proceedings, high court costs, right? And therefore it is not cost-free. And therefore law and economic scholars maintain that in such a situation there should be no rights at all. Now I give you, that sounds very, unbrotherly, but I give you two examples which might illustrate that this is not so far-fetched, this solution. The one case is from Germany in the 1920s when civil aviation came up and when Lufthansa started its business. And then there in Berlin they built a big airport and the machines started from Berlin airport And there was a chinchilla farm. I think I gave you that example. Did I give you that? There was this chinchilla farm. You know, this chinchilla farm example. And the plaintiff first wanted to make an injunctive use against Lufthansa, which was denied by the court, but he was granted damage compensation. Later on, the case was moved to the Supreme Court. The Supreme Court said there is no damage compensation and no injunction, because it is so obvious that this is an important economic activity. We had a similar case in the 1920s when in Dortmund, which is a big industrial city in Germany, 7 or 8 steel mills were built, you know, in one big industrial area, and the farmers around made use of their injunction. They said, we have an injunctive right, so they wanted to close down the steel mills. And that was decided in the same way. The Supreme Court said, this is the more, let's say, this is the more valuable use, and we cannot close down a factory which gives jobs for, in that case, 30,000 people, just, you know, for the benefit of some farmers. And again, the farmers had to adapt. They did not even get a damage compensation. And the third and last case is the following. There was somewhere in Germany a mountain, a large mountain, which belonged basically to one person, but there was a small slot, a small piece of land, which belonged to another private person who built a house on it, a small weekend house. It was in the hills, you know, and he had his weekend house in the hills. Now the owner of this mountain used this mountain as a quarry, you know, to carry stones, and to get the stones out of the mountain, he had to use dynamite, explosives. So all the time there were explosives, and this was necessary for the quarry to carry the stones out of the mountain. Now, each time when there was a detonation, you know, an explosive, when he used this explosive, there were cracks in the house of that man who owned the house. And he went, of course, to court, and he said he lost all the cases. Then he went to the Constitutional Court and said, this violates my constitutional right. Unlike in India, in Germany, private property is a constitutional right, just as privacy or religious freedom or freedom of speech. Property is also a constitutional right. So I said, he infringes my constitutional right as an owner of the house. And the Constitutional Court dismissed the case and said, this is not a violation. So again, this man did not get an injunction, of course, but he did not even get damage compensation. This is full in line, these 3 cases are full in line with economic considerations, because they economize on the cost of redistributing wealth from one person to another person. Now we come to the many cases in which the courts and nobody actually knows what is the best use. Sometimes it might be the victim might have the best use, sometimes the tortfeasor might have the best use. In that case, the best rule is damage compensation. Damage compensation is here, and this is important for you to understand, is not something, as the lawyers say, which makes the victim whole. It makes the victim whole again, but the rationale of damage compensation is not to make the victim whole. The rationale, the economic rationale of damage compensation in these cases is to establish a mechanism by which the dangerous or polluting activity which inflicts damages to other person, to let this activity prevail if it is efficient and not prevail if it is not efficient. Now assume, for instance, that we have in one case a relatively small neighborhood and a large factory. And we say that the factory must pay damage compensation to the small neighborhood. Then if assume that the damages are 100, but the cost of removing the factory would be much, much higher, then the factory would pay the 100, right? And would continue to pollute but pay the damages. But if it is the other way around, if the damages are 1,000 and the cost of moving or perhaps of installing a filter or something, at least reducing the damages, would be only 100, then this mechanism would lead the investor either to move away where there is no damage or to invest into anti-pollutive gadgets. See what I mean? So we have here the legal, the proposition or the recommendation of economists to the legal system would be to say this: the problem which you have to solve is not in a traditional way a problem of justice. The problem you have to solve is a problem of using land in a proper way, in an efficient way. And the legal norms, if transaction costs are very high, if transaction costs are low, there's no problem at all. You can have whatever legal norm you have, you will always end up at the efficient solution. Yes?
So when you give example that no rights is prevalent instead of damages, because
Yeah.
the cost of approaching court is high. But let's say that our system, the legal system is in place, is so efficient that whenever you approach the court for initial few years or few number of times, the outcome, the result is always that damage is paid. Let's say that is how it, because you have been inflicting harm on me, so you are supposed to pay the damage. Then once you know that every time you approach the court, it is going to be the result, then you'll stop approaching the court and you'll just follow this scheme of paying the damage. In that case, it would just be a redistribution of wealth and no extra cost would be incurred.
Well, if we have 100% legal certainty, if we would arrive at a situation of 100% legal certainty, then the argument applies. You are right. So, yes, but still you have costs. You have cost of the transfer. Every transfer of wealth comes together with, is associated with the cost. You cannot avoid that totally. And therefore, at least, I mean, your argument is very sound, very good argument, but still, I mean, I refer here to the literature, and they say, and I refer not only to the literature, but also to the legal practice. And the literature, but also the legal practice, does not arrive at this result which you propose. The problem is I cannot go here too much into the legal dogmatic doctrinal things which are too difficult here for this audience. But in Germany, we have a doctrinal rule which is used in such cases, which we call Ortsüblichkeit. I don't know whether anybody of you speaks German, but Ortsüblichkeit means as much as usual. So if it is usual to have, if you have a zone somewhere, and if it is usual there to have industry there, and there's one house, one residential house, and then this residential house cannot say, oh, I want damage compensation from all these polluters. That is the doctrinal, in a nutshell, the doctrinal way of putting it in Germany. But it has taken a long time to come there. I will deal with this later. So whenever transaction costs are high, then the problems become real big problems, and then we have to think about how to allocate the norms, the legal norms, so that they are in the position to steer the resources in an efficient way. Okay. Now I move to the next point, that is property rule versus liability and the commons and the anti-commons problem, which is a very important topic worldwide and a fundamental problem. Now, I have to start here with a legal differentiation, which for the lawyers might be boring now, but everybody must understand. If you don't understand, then you do not understand the rest. When we talk about a right or an entitlement, then there is a fundamental difference between two types of rights, namely absolute rights and relative rights. Now, can one of the lawyers explain to me the difference, or to the rest of us? What is an absolute right and what is a relative right? Pardon?
An absolute right would be something that I completely and totally possess.
That I completely?
Totally possess. In the sense, I have been owed that by the state. While a relative right would be a right against someone or in comparison to someone. So, for example, a right not to be harmed would be an absolute right. And a relative right would be, say, if there's a breach of contract and I am being assured compensation, so relative to the opposite party, I have a right to compensation.
Yes, thank you. So, the difference is this. An absolute right, if you are the owner or the bearer or the holder of an absolute right, this means that you can defend this right against everybody, against the rest of the world. No matter who infringes this right, you can take action against anyone, the whole world. That is an absolute right. So, for instance, private property is such an absolute right. If somebody builds, for instance, trespasses your piece of land which you own, then you have a right against him, no matter whether he is, let's say, a squatter or the king of China or whoever it is. You have a right against everybody. That is an absolute right. Or, for instance, the right to bodily safety, integrity, not to be assaulted is also a right, an absolute right. There are many other absolute rights, but this is important to understand. Whereas a relative right is a right which, for instance, comes from a contract. So if we have a contract and I do not perform with my specific performance, then you have a right against me. But do you have a right against others? If I sell you something, for instance, and then do not deliver, then you can take action against me, but not against anybody else, right? So that is the difference between a relative and an absolute right. Now the problem is, however, that sometimes it is not clear whether something is a relative right or an absolute right, or it is debated whether something is a relative right or an absolute right, and that can lead to big, big problems. And I just want to give you two examples of that. Does anyone know this name, Calder? No. But you all know what a mobile is, right? As children, our children, they had all these mobiles in their rooms. Now, Calder was an American artist who invented the mobiles, but not these small mobiles, you know, which we sometimes have at home, but large, big constructions. And when you travel in the United States, he lived in the 1940s and 50s. When you travel in the big cities like New York or in Chicago, with these skyscrapers, then you find these mobiles. They are sometimes 6-8 meters, and they move slowly. You know, they are constructions which are moving and give this rigid construction of the skyscraper some other element of movement. You see what I mean? Now, so he was a famous artist in the 1950s, and Calder made such a mobile and sold it to an art gallery. Now the art gallery sold it then to the airport authority of Cincinnati County to be posted, to be placed into the big entrance hall of the airport of Cincinnati County. Now the director of the airport did not like he said that this mobile can be improved. So what he did, the mobile was in black and white colors, and he asked a painter to repaint the colors in pink colors of Cincinnati County. And also he did not like that the parts of this construction would move, so he asked a plumber to fix it so that it could not move. And Calder, of course, was not amused about this. I mean, actually he was very excited that somebody misused his piece of art in such way. So he went to court and filed for an injunction and said, you cannot do this, you must place this piece of art into the original position as it was before. But the owner, Cincinnati Airport authorities, so they said, well, you have no right. You have no property right because you gave up your property. I'm now the rightful owner. And you have also no relative right because we have no contracts at all. So you have no rights at all. So Calder was so disappointed that he moved the case up to the Supreme Court, and the Supreme Court decided that Calder has no rights, and that therefore what the airport in Cincinnati County had done was lawful. Now a similar case was in France, also in the 1950s, when a painter, at the time famous painter, had painted a refrigerator, all three sides of the refrigerator and the top also he had painted, and then sold it to a gallery. And the gallery, because it wanted to make more money with the refrigerator, cut these into 4 pieces and sold the 4 pieces separately. And the painter, of course, who had this painted for a refrigerator, that was part of his idea of the painting of this piece of art, he went to court and also moved the case to the Court de Cassation, which is the highest court in France. And the French court now took a decision which was completely different from the American decision. The French court said, the artist has given up property. That is right. So he has no property right anymore. But he keeps an absolute right at this painting, or at this piece of art, the right of an artist, which is also an absolute right. And no matter who the property owner is, he can always use this right of an artist and can file an injunction against any change of the piece of art. Now this French jurisdiction of the French High Court was later led to the so-called Berne Convention for the protection of the rights of artists. And according to the Berne Convention, which also the United States but also India have signed and ratified, it is now international law, but our national law in more than 100 countries, that if an artist sells his and gives up the title of his piece of art, he still keeps some right, and everybody who changes it cannot do it without his permission. So if I would, for instance, buy a painting, let's say an Indian painting here, and I say, oh, well, this lady with these green hairs, I don't like the green hairs, I want the hairs black or something like that, or the other way around, then I cannot do it without the painter's permission. And this is an absolute right, not a right which I could also, the painter could say, okay, we make a contract, you cannot do this. Okay, then I cannot do it, but it is only a relative right. If I sell it and the next property owner does it, then the producer has no right against them. So this is just an illustrative example. Now I come to a much more economically important example where you see how the question whether something is a relative right or an absolute right becomes very, very important, and also even leads to conflicts between countries, between nations. That is the rule of exhaustion in patent law. You know all what a patent is, right? The patent, you have heard it yesterday, I think the day before yesterday, Saturday. Now, assume there is a patent holder. Let us assume there is a Swiss company which holds a patent, let's say, for pills against some widespread international disease. Let's say against AIDS, a pill against AIDS. So it has the patent. Then this patent is, this is totally undisputed, not a relative right, but an absolute right. So whenever anybody in the world infringes it, he is protected by this right. It is an absolute right which protects him against the rest of the world. Okay. Now assume the following. Now assume that this Swiss company makes a license agreement with an Indian company and licenses the Indian company to produce this patent for a fee, to produce this pill for a fee. Then the Indian company has now a relative right, a contractual entitlement to produce and market this pill in India. Assume that it's in the contract like that. Now assume the following. Assume that the Indian firm makes a sub-license with some other Indian firm to produce it. So we have now two contracts. We have a license contract between the patent holder and the Indian company, and the Indian company makes a second sub-license contract. And now assume that this sub-license contract between the Indian producer and the other company in India is not covered by the entitlements given in the contract between the patent holder and the Indian company. Then there is general agreement among all lawyers that the Swiss company loses its patent right, its absolute right against the subcontractor. It cannot go, it cannot, it has no entitlement against the subcontractor from patent law. The only thing it can do is it can say, it can go to the contractor and say, well, you see what you have done here, the subcontract, that is not in line with our agreements. That is a breach of contract and you have to pay me damage compensation, but the patent protection is exhausted as soon as there is a subcontract. There is an economic rationale behind this, but I don't want to go into that. I just hope you have understood it, that a right which was originally an absolute right now becomes all of a sudden a relative right. And the Swiss company must deal with the Indian company, and the Indian company must then say to the subcontractor, well, you know, we have to change the contract or whatever, and if they cannot do it, then they must pay damages or whatever. But the patent right with regard in relation to the subcontractor is exhausted. We call this the exhaustion of patent rights by a license. So this is also out of question. But now comes the interesting thing. Now, yes? Yeah.
So what is the basis of then French jurisdiction on that?
Well, that is a question which I cannot answer in 5 minutes. I'm sorry, but my answer simply would be that, of course, any legal order is free to organize any problem, any legal problem, by either issuing relative or absolute rights. There is nothing written in the stars or in stone that this must be a property rule, that this must be an absolute right and not a relative right. There are good economic reasons for doing this, but you know, I have to proceed a little bit, but we can talk about them. But you know, the law as such, there is nothing which prevents the law from having certain features in one country which it does not have in another country. And what might be an absolute right in one country might be a relative right in another country, you see. I just wanted to illustrate you that this is not a God-given distinction, what is an absolute right and what is a relative right. See what I mean? Now, let me come to the exhaustion of patents again. Now comes the following. Assume the Indian company makes a contract, a license contract, not with another Indian company, but with a foreign company, let's say with a South African company. So the Indian company has a license and makes a sub-license contract with a company in South Africa. And they produce now this pill and can sell it at low prices. Now the question is, what can the Swiss firm do in South Africa? And here we have a huge clash between the interest of developing countries and, let's say, countries like Switzerland or those who produce much medicine and so on, the big medical companies. It is unclear. So it is unclear whether the license leads to an exhaustion of the absolute right only in India, that is the country with which the original contract was made, or whether that extends also to other countries. And here the view of countries like India is that the exhaustion is total. That once you have made a contract, a license contract, and then if the licensee, you know, makes more contracts, then it does not play any role whether the licensee is in India itself or in some other countries, and therefore the company in Switzerland cannot use patent law and file a case against the company in South Africa. It can only take action against the company in India. And it can take action against the company in South Africa only under the condition that itself has a contract, which it, however, does not have. And this is an unresolved question. So you see, the question of whether something is an absolute right or a relative right is often not clear. In most cases it is clear, but it is not necessarily clear. So this is one thing. Now I come to another very important legal categorization, namely property. What is property? Now property, first of all, unlike a contract, leads to an absolute right. So whenever we talk of property, we mean absolute rights, and it makes no difference whether this is private property or any other form of property. Property is always expressed by absolute rights. But we have many, many different forms of property, or what we can call property. And we have different forms insofar as property defines the competences, the absolute right competences of different groups of individuals with regard to a resource. Now, the when we think of property, what we mean private property, that is the property which we inherited from Roman law. That is, we have one owner and all competencies with regard to the resources are concentrated at this one owner. So if you have, for instance, a piece of land, then private property, according to the Roman perception of property, which goes back even to the times of the Roman Republic, to 2,300, 400 years ago, private property means we have a resource, and whatever you can do with the resource, all the competencies with regard to the resource are concentrated in one person. So, for instance, the right to use it, the right to sell it, the right to use it as a pledge, the right to get the fruits of whatever that the land, for instance, produces, usus fructus, as we call it, everything which can be done with a resource is concentrated at one single owner. On the other hand, we have the other extreme from Roman law is a form of property which is called res omnium, or in English, free access. That is, everybody has the same right to the resource. Now, assume, for instance, free access is or has been, at least for a very long time, the organization of resources and the competencies to resources on the high sea. So outside the territorial borders and the 3-mile zone, there is the high sea. And on the high sea, we have res omnium. That is, res omnium means if there are fishes, then everybody in the whole world has the right to catch these fishes, right? And this is also an absolute right. Nobody can take this right away from him. It is not based on a contract, it is an absolute right. It is the right to catch the fishes, for instance. Then we have another organization of property. That is the common, here common with that double M, there's common property. Common property and res omnium, that is free access, is not the same. Common property means that property, for instance, land, is owned not by the whole world, everybody in the whole world, but by a small group, a relatively small subset of all people. Let's say the villagers of the villagers of a village might have a commons. The grazing land is owned by the villagers, right? Or in the Alps, for instance, the Alps, the highway, you know, where you have the cows in the Alps, that is commons. That is owned by all people in the neighboring village. And you can have mixtures of common property and of property, of private property. So it is, for instance, possible that you have a forest, and the forest has a property owner, but he has not the exclusive right to all uses of the forest, but he has only limited rights, and there are others who have also rights on in the forest. For instance, in Germany, our proper land property has its root in the law of Germanic tribes, where it is much more common property rather than this Roman idea of property. And we have large pockets of Germany where there is one owner who owns the land. There is another owner who has also an absolute right to catch all or to hunt the animals. He has the hunting rights. And the hunting rights is something totally different from the land rights. So I remember that when I was became a professor in Hamburg, I lived outside Hamburg, and we had rented a flat in a house with a huge piece of land around it with some trees and so on. And on one Sunday morning, I was sitting on the terrace with my family, and then some people came to our, on the land and started shooting. You know, they had rifles and started shooting. And I said, what the heck are you doing here? And they said, well, we are killing certain birds, and it's all okay because we have the property right of hunting here. So they showed me, you know, their certificates and so on, then they went on shooting. That is possible. Or, for instance, it could be that somebody owns a forest and the villagers have a property right, an absolute right, which nobody can take away from them, to collect the wood, the wood which falls down from the trees, to collect it for their households. And the question is, of course, there are many others, but for reasons of time, I do not get into Kommende and Manure and so on. So we concentrate here on private property and on common property and on free access, that is res nullius. The question is, what kinds of property are preferable from an economic perspective, and to what pitfalls or what, let's say, negative impacts can these types of property lead if transaction costs are not, as in Coe's world, zero, if we have high transaction costs. And this question about how should property look like, how should it be, how should property rights be tailored if transactions costs are very high, that led to a very, very fruitful debate, which is known under the label the tragedy of the commons and the tragedy of the anti-commons. Perhaps I might, before I now come to the economic analysis, I might give you one example about what happens if, for instance, common property or property which has some elements of common property is changed into private property. Now, you know all Karl Marx, you know, the radical economist and philosopher of the 19th century. And the first article which Karl Marx ever wrote was in 1844 on this problem. It was exactly on this problem of changing land property rights. Now what has happened? Marx he is from a family in a region in Germany which during the French Revolution became French territory. So I think in 1794 it became French, but then after 1815 it became Prussian. We had no German state at the time, so it became part of Prussian territory. in 1850 with the Vienna Congress. Now, when this land became French, then in the year 1800, the French issued the so-called Code Civil. Have you heard of that? The Code Civil, that is the French civil law. French civil law. And that became the law, the civil law for the whole of France, including this part where Marx was from. And in the Code Civil, they have a rule of private property. That is, the landowner, there is one landowner, he owns everything. And that Code Civil was introduced in the year 1804 in this area, in the Rhineland area, where Marx is from. And so overnight, the villagers lost, consequently, because it was now pure private property, the villagers lost their right to collect wood, which for these poor villagers was, was an income, a considerable income loss. Now, when that was introduced, the villagers did not care, and it was not much enforced, so nothing really changed much. So there were it was on paper, it was now all under the control of the owner, but the villagers still picked up their wood there. But then later on, when it became again Prussian, the Prussians decided that for this area the Code Civil should prevail. They did not reintroduce the old laws which they had before. So they kept the French law there. And then they enforced it. And they even enforced criminal sanctions. They imposed criminal sanctions against the villagers who, as they had always done, collected the wood. And they were now, they could be sent to prison up to 5 years. And that led to riots there in this region. And that led Marx to write his first article ever that had to do with changing property rights on land. Now we have to say now that the Code Civil is the much more efficient use for a forest because if anybody can come and take the wood which lies on the ground, then this leads to underinvestment on the side of the farmer. But that is another story. Now, let me first refer now to a famous article by Calabresi and Melamed, 1982, called Property Rule versus Liability Rule. And Calabresi relates this article to private property, a private property in which all the uses of a resource are concentrated in one hand. So there is it's not common property or not some mixed forms of property, but it is really property as the pure Roman property. One person owns everything, has all the competencies over the resources. And Calabresi then asks, how does the legal order protect this property if it is infringed? All right? And he says the legal order tells us that there are two ways of protecting property, or protecting an absolute right in general. It does not only relate it to property, but to all absolute rights, which you can defend against the rest of the world. And he says that we have, in principle, two ways of protecting an absolute right, namely an injunction and damage compensation. That is what you already learned before. So these are the two methods of protecting an absolute right: injunction and damages. And now Calabresi asked a question which nobody had asked before. I mean, that that we have injunction and that we have damage. Of course, every lawyer knows, and even the non-lawyers know that. But Calabresi asked now the following question. He says, if we have the owner of an absolute right, then why at all do we have damage compensation? Why is it not enough to protect an absolute right exclusively by an injunction? That was his very intelligent question. Because he says, if an absolute right is protected by an injunction, then it is clear that this right, that this title, this ownership title, and this right, and therefore also the use of the resources, will move to another user only if the other user values it higher than the present user. See what I mean? So an injunction guarantees that the right will be transferred from person A to person B only if and only if person B values the right higher, right? So if you, for instance, have a person A who owns a forest and has an injunction against everybody, then this is guaranteed that this that B must pay him a price which is higher than his own valuation, and that guarantees that resources move from the lower valued use to the higher valued use. And that is one thing which is an absolute necessity for a market economy, that resources, whatever resources, move from the lower valued use to the higher valued use. And this is guaranteed. It can, with an injunction, it is never possible that a resource moves from a higher value to the lower valued use, right? And this is very important for the functioning of a market economy. And therefore, he said that, so to speak, the most natural protection of property or of an absolute right in general is the injunction, because the injunction guarantees voluntary transactions and excludes involuntary transactions. And now comes the problem with this. And I give you some examples of showing why sometimes the heavy protection of property by an injunction can lead to adverse effects. Now, the first example is about the Industrial Revolution. Now, when the Industrial Revolution started in Europe, the common view among lawyers was that the land and that property in general, a problem which is today called the problem of the tragedy of the anti-commons. Now, before the Industrial Revolution, we had also all kinds of emissions, of course, but you know they cancelled each other out. But now with the Industrial Revolution, we had all of a sudden emissions, let's say, coming from one factory, and they were 5 times, 10 times, 50 times higher than all other emissions around. And they could not easily be abolished, given the technology of the time. And what happened now was this. The owner of the surrounding land filed for injunction. So there is a famous court decision of the House of Lords, that was then the highest Supreme Court in England, regarding Manchester. There was a copper mill in Manchester in around 1770. And this copper mill produced loud noises. It was noisy. Now, all the landowners around the copper mill, from far and not so far, filed an injunction. They went to court and said, this is too loud, that is a forced servitude. That was the legal opinion at the time. It is, when we have to suffer, this is like trespassing, and it is a servitude forced upon us. They use our land, that was the legal view on that. This copper mill uses my land to produce copper, and he must buy the servitude, then he can do it, but he cannot do it without buying, by getting the right from me and buying a servitude from me. So all these landowners filed for an injunction and got the injunction. Now you can say, if the Coase theorem applies, what would then happen? What would happen in this case? You know, the owners, the landowners around this copper mill, they file for an injunction. The court says, yes, you get this injunction. And then they say, dear Mr. Copperfield, or whatever that guy is, here, you must close your, close. Then, if the Coase theorem applies, what would happen? The exactly, the copper mill owner would say, well, look, I know that this is something very negative for you, but we can sit together. I compensate you for the damages, and perhaps even more than the compensation, and we make a contract, and you are not worse off, and I'm still better off as if you make use of your injunctive rights. That would be the Coase theorem, right? But this did not happen. This did not happen because the transactions costs were so high. There were hundreds of landowners, and even if he made 100 contracts, he could. Then there might be, it might not work, because then they left one out, and this one could again close the factory, and then is in a hold-up position and can extract all the rents and all the profits from the copper mill. This was the problem of the early industrialization. And as late as 1850, the House of Lords, the highest English court, granted an injunction for the owner of a large plot of land near the city of Hull, through which a river was flowing. river was flowing through the city of Hull, and he was outside the city, and this river was used for the, you know, for the dirty water, the excrements of the people and everything, that all went into the river. And he owned this, at the time that was the law, he owned this river also, this part of the river. So he said, what you are doing here, you are trespassing here my property, I make right of the injunction. Now I don't know how that case lately was solved, because if that court order had been one-to-one executed, then it would have resulted in the whole city of Hull would have been closed. That did not happen, obviously. So we have many such cases also in Germany. And these the lawyers at the time, they came very close to causes inside. They said, well, you know, this is that the owners of the land have to tolerate this. That is not right. That is, the law is they must not tolerate it. And if they tolerate it, then only by a voluntary transaction, that is not by a forced servitude, by a transacted servitude, which is established against a price. But this did not work. So the idea that this can all be worked out with voluntary transaction was simply wrong. And if that had not been changed, then the Industrial Revolution might have been killed in its cradle. And this led, in the 19th century, in countries also in Germany, to legal developments which gradually shifted, removed this concept of Roman law to a concept in which this right of an injunction was removed more and more to a right to damage compensation or to no compensation at all. So, for instance, in Germany, my country, the Industrial Revolution started much later than in Britain, only in the 1860s, and it was characterized first, in a first step, that the large majority of all lawyers said private property must be protected by an injunction, period. And they did not care about whether the transaction costs were high or low, and they said that if that leads to no industrial revolution or to no industry, then that is the necessary consequence. You know, we had lots of people in the 19th century who hated industry, or even at least didn't believe that it's something positive. And they said, well, that is the law, we have the law. If industrialization is in line with the law, okay. If not, it's also okay. That changed only in the late 1860s, when the German parliament issued a law which stated that if a company is licensed by the state, so you set up a company, and the activity is state licensed, then this annihilates automatically the injunction. So somebody could not file an injunction against a company which was state licensed. That was the first move away from this. And later there came other moves and so on, and then it was the industrial revolution or the industrial development was made in line with the legal order and with the definition of property rights by reducing the domain of injunctive relief and thus solving this, what we call tragedy of the anti-commons. You get the point? Okay. Now I come to a second example. You know what a squeeze out is in corporation law? Can you?
So in a squeeze out situation, what happens is that the majority shareholders are not willing to pay fair price to the minority shareholders for transfer of the shares because they own a majority control and they're able to take more decisions without minorities' vote. Therefore, minorities' vote does not carry the same sort of value as a majority.
Yes, but what has that to do with the squeeze out?
Squeeze out can offer lesser price than the order.
No. No. Squeeze out is somewhat different, the squeeze out problem, and I don't know even if it exists in India. But now assume you have a merger of two companies, two stock-listed companies in India. They merge. Let's say two cement factories merge. But there's one cement factory where you have a minority shareholder who has, let's say, 4% of the shares. So the company which buys all the 94%, 96% of the shares buys the 96% at some price, but it wants to have 100%, right? It would like to have the 100%. And it now goes to this minority shareholder and says, well, you know, your shares are worth 100 rupees per share, so you have 100,000 shares. We pay you 10 million rupees, or we pay you 11 million rupees. That is more than the shares are worth. But now it becomes profitable for this minority shareholder not to sell his shares. Why? Because for the following reason. Now assume that both these companies were stock-listed companies, right? And now the second company becomes a subsidiary by the merger, becomes the subsidiary of the buying company. Then the buying company has an interest that the subsidiary should not go public anymore. It is just a kind of department. And if it holds 100% of the shares, then it can, without changing the character of the company as a limited corporation, it can, however, it can decide not to. It can decide to economize on all the costs of going public, you know, publicizing balance sheets in newspapers, informing the public on a monthly basis and so on. This is very costly, of course. So for this reason, the company can have, has a big interest in getting 100%, because then the law allows not to economize on these costs, because there is no public anymore which has to be informed. And now the 4% owners of the 4% can say, well, 11 is not enough. Pay me 100, because I know that how much you save in terms of not informing the public anymore, publicizing your balance sheets and so on. And therefore, the company can say this owner of the shares of the 4% is in a hold-up position and can blackmail, so to speak, the other side. And therefore, the law in the United States, in Europe, also in all European states, allows to not to buy these shares, but it allows the private company, which owns already at least 95%, in some countries 90%, to buy the shares at the market value, not more than the market value. Even though the owner of the shares does not want to sell them. You see? So here the owner that is what we call a squeeze out. He is squeezed out. He loses his ownership rights by an act of a forced transaction. But again, this is an instrument of breaking the tragedy of the anti-commons, Now I give you another example. I'll leave this third example and give you example number 4 now. This is an example which the author of this book about the tragedy of the anti-commons used. In the Middle Ages, waterways were privately owned. Now assume you have a waterway like this, and then you have the people who own the land at the waterway. Then they owned the waterway up to the middle of the water, and the people who owned the land on the other side owned also the waterway. So if you had a river, like the River Rhine, for instance, which is one of Germany's most important waterways, you had hundreds and thousands of owners. Now, what was the consequence of that? Now, assume you have this waterway, the River Rhine, and you have all the barons there. They were called robber barons because they owned the land left and right of the River Rhine. And there were hundreds of them. And each of them had the right to collect fees whenever a ship came up, right? So there were hundreds of private tax collectors, and a ship which went down the River Rhine had to pay taxes or fees, every 3 or 4 kilometers whenever there was another owner. Now again, this would not be a problem if the coast theorem would apply, because then the owners, they would all coordinate and then calculate a fee which is profit maximizing, but which might also be socially tolerable. But now, because they cannot coordinate, you have a development of fees, and this led to two shortcomings here, or to two negative consequences. First of all, there was heavy underinvestment in the Rhine. These waterways, they have to be kept in order, there has to be investment and so on, and there were underinvestment because everybody said, well, I don't invest, the other can invest. They could not coordinate their interests. The second was that due to the high fees, the Rhine was underused, so it led to an underuse of the river. Just like in the Industrial Revolution, the injunctive right led to an underuse of the industrial firms. So it was therefore for a merchant in the Middle Ages, it was cheaper to use an oxen cart rather than to go up the River Rhine, even though an oxen eats every 50 kilometers his own weight and was economically, from a social point of view, it was the much more expensive method of transportation. And it was only in the year 1800 when Napoleon, he nationalized the Rhine. The whole Rhine became French territory. And after the Napoleonic age, the Rhine became again the border between Germany and France. But all these states which had a stake in the Rhine, that was Switzerland and Baden and France and so on, Netherlands, they agreed that the Rhine should be kept under an international authority, and that the international authority had all the rights on the River Rhine. And that, only that contract, international contract, made it possible that the River Rhine then became one of Europe's biggest and most important waterways. Before it was not possible, because we had, everywhere we had private owners with veto positions. You had thousands and thousands of private owners, each having a veto position. Now, I give you a last example, which is a current example, and which shows that this tragedy of the anti-commons is not, let's say, a historical problem. I have taken examples from history, but you should not make the mistake to believe that this is a historical problem. It is one, perhaps today, one also of the biggest problems we have, especially in patent law. And I just want to illustrate this again with one example only, because of I have little time. You all know what a DNA sequence is, right? Of, you know, the DNA sequence contain all the information of a living creature, let's say of a fly, which can be used for medical purposes. Let's say the DNA of a particular fly, which researchers use for research. And it is very important to know the full gene sequence for this fly, because then you can change the genetic compositions of the fly and so on. So it is very, very valuable for researchers and research institutions to know about the full gene string for this fly, for this animal, let's say. And now the question comes, there is the following question here, is a question of patent law. Now assume you have this length, this is the length of the gene sequence, and that length contains all the information about this particular this particular bird or fly or animal or plant or whatever it is, you know. But this whole sequence consists of subsequences which can be separately analyzed. And now the question is, now assume that there is a company which has not found the whole sequence, but has found and decoded a subsequence. Now assume there are 100 subsequences, and you have found one subsequence. The question is, should the subsequence also be patented, or only the full sequence? And you can say, you know, the law itself doesn't tell you, because to find the subsequence is an achievement, and if you find 100 subsequences, then it's a big achievement, right? But the problem is here the following. If you patent each sequence, then at the end of the day you have 100 patent holders. And then you have in patent law exactly the same situation as you had with the River Rhine 200 years ago, right? You have 100 patent owners, each of them endowed with an injunctive right, which leads to all these negative consequences and to an underuse at the end of the day of these resources. And therefore, the US Patent Office has therefore in the year 2015 denied to patent a subsequence of these genes to avoid this, to avoid the tragedy of the anti-commons. But the European patent law has granted a patent for the subsequence, obviously not knowing or not understanding the economics behind it. And here you see how important it is for lawyers to understand what they are doing. And the lawyers, especially in patent law, often they don't understand economics, they don't understand what they do, they don't understand that patent law often reduces rather than increases the incentives to new research, and that is what comes out. This is a very good example about what happens if lawyers have no idea about the consequences of what they are doing. Now, I come back to Calabresi. There are cases in which this hold-up problem does not exist, or in which it can easily be removed, and there are cases in which it cannot exist. And therefore, Calabresi says, if transaction costs are low, right, and if the real-world situation is close to the Coase world with low transaction cost, then we should have a strong protection of private property, but of all absolute rights, because then you can take advantage of this qualification of this property that this guarantees a voluntary transaction and the higher valued use. But if transaction costs are very high, then you might end up in this tragedy of the anti-commons, and then a forced transaction, which then might lead to a property, then might lead to only to a damage compensation, might be preferable. You see that this is a very, very important point here, this differentiation. So, for instance, when it comes to protection of privacy, privacy is also an absolute right. So, yes, please. Pardon? Yeah, the conclusion of Calabresi is, he says that whenever the real world situation is such that transaction costs are low, right, then a property right, or an absolute right in general, not only property right, should be protected by an injunction, because then you know, a voluntary transaction takes place, and if the voluntary transaction takes place, this guarantees that the absolute right goes only from one person to another person if this person values it higher. But if that is not the case, if the for whatever reason, for reasons of hold-up positions, for reason of many people who cannot coordinate, transaction costs are very high, then it should be possible to some extent to infringe the right of other people against compensation. See what I mean? Now, for instance, I give you an example where it is clear that an injunction is better than damage compensation. That is privacy. Now, you know, public people, celebrities and so on, they are often subject, you know, to the yellow press. So they take photos of them and their family, their children, and everything, and so they want to be protected, right? And here one can say, okay, this should be protected by an injunction. So if this celebrity learns about it beforehand, it has an injunction, say don't do it, and they must stop it. But usually they don't learn it, they don't know it before, they see it in the newspaper, and they cannot file for an injunction, not because they don't have the right, but because they have, because they didn't have the information to make use of their right. In that case, there is still a possibility to make the infringement of the right unprofitable. So I told you that, for instance, in the case of the Industrial Revolution, the injunction was replaced partly by damage compensation, right? And the damage compensation is the damage which the person had. But otherwise it is now, what happens is a forced transaction. That is, the copper mill can now make noise on all these surrounding on all the surrounding pieces of land, and they cannot do against it, but they get some damage. They get damage compensation for it. But this is only to make the tragedy of the anti-commons impossible. But here it is different, and therefore, so the argument goes, in such a case of the infringement of privacy or intimacy, it should be protected by an injunction. But if the injunction does not work because the person who suffers from the violation of his right did not know this beforehand, then the damage compensation must be higher. It must be so high that that the person who infringes a right loses all of his profits, not only the damage compensation, if private transactions are easily possible. And this is actually what happens, or what we often find in cases of protection of privacy. Now, I give you two examples again from here. German. The one is a German case, and the other is a case which went up to the European Court of Justice. Now, what happened? The first case is a famous case of Caroline of Monaco. Have you ever heard that name? Caroline of Monaco. We have a small state in Europe. Monaco is an independent state, you know, but it is a first. The Duke of Monaco, and one member of this family, royal family or Duke family, is Caroline, you know, and she's a kind of celebrity in Europe, and the paparazzis are always after her, making photos, and she had also several husbands already, so she is, especially the kind of person who is interesting for the yellow press. Now this Caroline of Monaco once went to an Italian restaurant with her children. You know, they were just going to a restaurant, eating spaghetti or whatever, so it was nothing intimate, but it encroached her privacy, because in European law, such a person like Caroline of Monaco, who is a member of the ruling house, she has no privacy insofar when she gives a public speech or something like that, or moves in the public, then she's a public person and everybody can take a photo of her and can publish it. But when she goes to an Italian restaurant eating spaghetti with her children, then that is privacy, and she didn't want this. So she went to court, and the court granted her damages. But now the question is, how much damages? I mean, what is the damages in such a case? It's not high, huh? I mean, it's difficult to say what the damage is. But here, the lawyer, I know the lawyer personally, he's from Hamburg, and I discussed the case with him. The lawyer said to the court, and could convince the court, that in this case, the whole rationale of protecting private property, not private property, privacy here, which is also an absolute right, would totally be destroyed if one would give a compensation. Now, you could, for instance, say 5,000 euros or so. But the corporations, they make, you know, these yellow press, they make huge profits with this, if they have all these photographs of Caroline, because she's such a celebrity person. So he said, we must disgorge the profits, not pay compensation, but disgorge the profits. Then the court said, yeah, but how much are the profits? And then I discussed it with him. We said, okay, this is a yellow press, this is a weekly magazine, and they also advertise. So this was a 2-page article, so we calculate what the advertising of the 2 pages, what that would cost, and that is roughly what they earn with 2 pages, right? And that was 180,000 euros. And the court granted 180,000 euros to her. And this worked, because such things happen very seldom now in Germany. Disgorgement of profit. That also protects a property right from being infringed, whereas the damage compensation, the economic rationale of the damage compensation is not that the transaction should not happen, but that the transaction should happen. But it is an involuntary transaction for reasons which we discussed, for reasons of the tragedy of the anti-commons. You see? I give you another example of how the law protects an absolute right when transaction is easy, when transactions costs are low. And I was, a couple of years ago, on a dinner party and was sitting together with a lawyer. And he said, well, I just had a case which is very seldom. That happens only once or twice in your life. And I tell you the case. So I said, one day there came somebody to my office, an author, and he had written a book with the title, My Flowers in House and Garden. He had written this book, he had sold some 20,000 copies of it and so on. It was not a bestseller, but okay. And then he had another book which had a similar title, Flowers in Garden and House or something. The title was a little bit different, but it was a much bigger book and with very fancy pictures in it and so on. It was from Bertelsmann. Bertelsmann is one of the biggest publishers in Germany. Now the problem with this book was that the photos were all made by Bertelsmann, you know, by very professional photographers, but the text, 95% of the text was taken from this man. So they had infringed his property right. And here there is no tragedy of the anti-commons. They could have asked him and say, are you willing to sell this to us, and what are you willing to what is your price? So this lawyer then said, okay, we write a letter to Bertelsmann and wait and see. So he wrote a letter explaining the case, and he said, I come back after 2 weeks. He came back, and Bertelsmann had written them a letter and said, we apologize, it's really, it escaped we didn't want to do this, we apologize, our legal department made a mistake, and so on. And they said, of course, we will fully compensate the victim here, and we offer him 20,000 euros. So the author said, well, that's not bad, 20,000 euros. If they had offered me 20,000 euros, I would have sold this, my copyright, for 20,000. Then the lawyer said, well, you know, let us first look how much money they made with the book. We can try to find this out. And they have a duty to reveal this, you know. So he wrote another letter and said, well, before we make a decision, we would like to know, because we have a right of disgorgement of your profits, how much money you made with the book. And then he said, then they sent one letter after the other, and it came out that this book was the book of a book club. You know what a book club is? Yeah? You join a book club and then you pay a certain fee, and then you can, every year, let's say you can buy 5 books, let's say, you get 5 books. But if you don't order the books, the 5 books to which you are entitled, then they send you, instead of your order, the so-called Book of the Year. The Book of the Year that is sent to everybody who is member of the book club but has forgotten to order all 5 books. And these are very, very many. And they had made this the Book of the Year. And then it turned out that they had sold hundreds of thousands of these books, and then they came up, you know, 50,000, 100,000, 200,000, and they settled the case at 1,050,000 euros. So now you can say, is that just or what? Well, it is, perhaps you can say this is an overcompensation of this guy, But from an economic point of view, it is exactly the right thing to do. Because if this author had only been entitled to the damage compensation, 20,000, let's say, then Bertelsmann and everybody else could say, well, whenever we publish a new book and we plagiarize from other authors, we wait and see, we watch and see, we simply do it, and when they come, we pay them the damage compensation. And if they don't come, it's our profit. So, therefore, because transaction costs are here low, we must give the publishers an incentive to make a voluntary transaction. And for that to happen, it is necessary to guarantee that in such a case they make no profit at all with their book. And then they have an incentive not to infringe an absolute right. So you see, when I'm roughly at the end of this, when I now add this up, then I can say the following. We have in private law, in private property, sometimes a situation in which the concentration of competencies on a resource in one hand has adverse effects because it leads to the tragedy of the anti-commons. And the tragedy of the anti-commons, to solve this problem of the tragedy of the anti-commons, it might be necessary to allow to some extent, involuntary or involuntary transactions whenever the transaction costs are very high. But if the transaction costs are low, then we should do everything to guarantee that the transactions are actually voluntary, because only the voluntary transaction can guarantee 100% that the resource only goes from the lower to the highest valued user. And therefore, we cannot say that when we concentrate property rights in one hand, that this is always the most efficient. It is sometimes property rights have to be diluted and allow to some extent their infringement, like the copper mills in Manchester. Otherwise, we get the tragedy of the anti-commons. Now, my last point on this topic here is the tragedy of the commons. Now, the commons is another form of property, of private property. Namely, the commons is a resource which is owned by a group. And there is this famous article of Hardy, perhaps you know, the economists will probably know it, of the 1950s, the tragedy of the anti-commons. Now the later research has revealed or has shown that Hardy was wrong, somewhat wrong, because the commons very seldom led to overgrazing or overfishing, because there was a small number of villagers who administered the commons, and they could, they could monitor. There was not much overgrazing, for instance, because they had a fierce administration of the commons, and they built fences, and they controlled how much every villager, how many sheep he could bring to the commons and so on. So the problem of overgrazing was not so big as Hardin told us. But what he meant actually was not the commons, but the open access. So that is a resource to which everybody has access, and which therefore cannot be, with reasonable cost, be well organized. And fishing grounds are a good example of showing this. Now, here you have, now assume you have a fishing zone. Let's say the fishing of anchovas at the coastal line of Peru. Peru it was very dependent on the ancova fishes, these small fishes, but they caught many of them. And then suddenly the yearly catch went down by 10, 20, 30, 40, up to 70%. And that one of the reasons was overfishing. And that is what we call the tragedy of the anti-commons. Now, assume here you have here the number of shipping boats which catch fishes. So this is from 0 goes, let's say here is 100. And this is the function. The more boats you have, the more you catch, but there's the law of decreasing returns. And then here you have even a peak, and then it goes down again, right? Now it is obvious that the efficient solution, these are the costs of fishing. And the cost of fishing is simply a linear function here of the number of vessels, right? If you have one vessel, you have a certain amount of cost. If you have 2 vessels, you have double the cost. With 3 vessels, triple the cost. So this is a linear function. And you can easily see that this is the optimal catch per year. Every year you should send this amount of vessels to fish, and then you have these costs, but you have these the value of the fish, and here by way of this, shifting this line to here, you have the most efficient, socially efficient number of fishes caught. Now assume that this fishing zone is free access. That is, everybody with his vessel, if he has one, can go there. Then it is not guaranteed that only this number of vessels will catch, and not more, because now assume we have this number, then nobody else should additionally go fishing. But of course, for everybody it is profitable to go fishing as long as his personal costs are lower than what he catches, than the average. And therefore you get to overfishing. You get too much fishes. And therefore it was necessary worldwide to establish fishing zone, and therefore to reduce or to abolish the free access to such fishing zones and other free access zones. That was necessary. Otherwise, we would have had a total depletion of international fishing grounds and also other things. And with regard to India, but also to other countries, there are these interesting findings of Ostrom, Elena Ostrom. Has anyone heard of her? She is an economist, the only economist who won the Nobel Prize. And she has found something interesting. She said that the tragedy of the anti-commons is the tragedy of the commons. Sorry, the tragedy of the commons was in India especially visible in the tribal areas. When India became independent, the land in the tribal areas became legally state-owned land. The state owned it. And this changed the incentives with regard to tribal land. That's what Elena Ostrom says. She says that before, when the tribes themselves managed the land, they were in a similar position as the villagers when they managed the commons, you know. They had a piece of land and only they had access to that, and then they could manage to avoid overgrazing and underinvestment. So you have the problem here of underinvestment and overgrazing, or overuse and underinvestment. Whereas in the tragedy of the anti-commons, you have underinvestment and an underuse. So it's partly symmetric, partly it's a mirror symmetry. Tragedy of the anti-commons, you get an underuse. Tragedy of the commons, you get an overuse of the resources. And in both cases, you get underinvestment in the River Rhine as much as in the tribal area. And she said that it was wrong, it is wrong to transfer all this tribal land into state land, because then the tribals, also in Africa we find this in the Sahara zones, in the tropical zones, they lose their incentive to invest and they lose their power to keep others away, and the state has not the incentive to step in, and then you get this depletion. So all in all, we can say that the allocation of rights of absolute rights, the protection of absolute rights, is one of the really difficult problems, and it is a problem which many lawyers do not fully understand. And if they don't understand it, it can have tremendous negative effects on the economy. It lasted many decades until the lawyers finally agreed that the tragedy of the anti-commons, which was caused by the injunctive right against any new industrial plant, that this was something wrong, that had to be replaced by something different. And even today, it is not guaranteed that the lawyers, those lawyers who really take the decisions, the powerful ones, that they fully understand it. And some authors say that in patent law we are again approaching a situation of the tragedy of the anti-commons, just as in the early Industrial Revolution. Whereas I think the problems of free access and overuse are today much better understood. I think the tragedy of the anti-commons has become common knowledge almost. Many people know it and know that sometimes free access might not be the right thing, and that it might lead to an overuse and to under investment, whereas the problem of the tragedy of the anti-commons is much less generally understood, especially among lawyers. but it is not less important. Okay, so then.